Hello lovely people, I'm sure you're enjoying our videos. As you've realized, our videos are in two parts. We've got the course-based ones that discusses the various sections of the law, and we've also got the everyday law. The course-based are designed for academic study and in-depth understanding of the law. But if you are interested in knowing about the law as it will appear or it will be useful for an everyday man, please always try and keep a focus on the everyday law content. It is done in vernacular and in simple and easy way said that the man on the street will be able to appreciate the law in his daily life. If you stand in need of any academic support for any of your law courses, please do not hesitate to reach the number below, either via call or by WhatsApp. Stay tuned for more of our videos on Supreme Law Publications. Welcome, friends, ladies and gentlemen, to our first video on Ghana legal systems and methods. Now, you remember in the introductory video, we mentioned that under Ghana legal systems, we, for example, try to appreciate what constitutes law in Ghana, what are the sources of our law, what are the things that we rely on to say that these are what determines the law that operates in Ghana. That is going to be the subject of our discussion in this video. So in this video, we will focus on the sources of law. Now, not to leave you in doubt or still brooding over what we mean by what we're doing, we'll simply turn to the Constitution 1992. Because the Constitution, as you may be aware, is the supreme law of the land. It is what prescribes the way the rules of government work and how individuals and the powers of state operate and also coexist. So if you are looking for law, what actually is law in Ghana? What are the sources of law? We cannot turn anywhere other than the Constitution of Ghana. All right, so we turn to the Constitution, Article 11. We are going to do a step-by-step examination of Article 11 so that at the end of our discussion in this video, you have a better appreciation of what we mean by the sources of law in Ghana. Let's join me and let's look at Article 11 of the 1992 Constitution. Article 11. Article 11, Clause 1. The laws of Ghana shall comprise A. This Constitution, B. Enactments made by or under the authority of the Parliament established by this Constitution, C. Any orders, rules, and regulations made by any person or authority under a power conferred by this Constitution, D. The existing law, and E. The common law. So you saw what the Constitution says, in part, and there is provision in Article 1, Article 11, Clause 1. It mentions that the sources of law in Ghana shall be, then there is an entire list there. Now let's do a step-by-step discussion of some of these sources of law so that you understand what we mean. It mentions that, one, it is the Constitution. Now, it is of enough significance and importance to understand that there is a reason why the Constitution is placed at the top of the hierarchy of our Ghanaian laws. The way the laws are mentioned under Article 11 of the Constitution was not just done erratically or arbitrarily. No, it is carefully crafted. So what you see under Article 11 is the hierarchy of the laws of Ghana. Which law comes first? And it mentions first that it is the Constitution. So the Constitution is the primary and supreme law of the land. Now, let's look at how the Constitution itself delivers as to the statutes of the Constitution. We'll turn and just refer to Article 1, Clause 2 of the 1992 Constitution. Let's see what Article 1, Clause 2 also says. Article 1, Clause 2. This Constitution shall be the supreme law of Ghana, and any other law found to be inconsistent with any provision of this Constitution shall, to the extent of the inconsistency, be void. You noticed in Article 1, Clause 2 of the Constitution, it mentions and says that the supreme law of the land here in Ghana is the Constitution. That is it. Or any law that is found to be inconsistent with the Constitution, to the extent of that inconsistency, is void. So guys, number one, the primary law in Ghana that we have, all right, or the supreme law of Ghana is the Constitution. That is the source of law. So if someone says that he's looking for the laws of Ghana, we are saying that the highest law that he needs to reach out to identify what should be the law in Ghana is the Constitution. Any other law should be subject to the particular Constitution that you have here in 1992. So Article 1 Clause 2 actually also adds that any other law that is inconsistent with the Constitution, to the extent of that inconsistency, is void. What does that mean? What it simply means is that if the Constitution says something and another law is created somewhere by any particular body, any person, any institution at all, and that law does not find reason with what the Constitution says, then that law will not work. That law will not be a good law in Ghana. It cannot be a source of law for us because that does not, or it's inconsistent with the supreme law of the land. And remember, notice the use of the phrase. It says that to the level of inconsistency. What it means is that sometimes laws may be created, not the entirety of the laws. Some portions of the law will be inconsistent with the Constitution. 1(2) is therefore saying that the part that is inconsistent with the Constitution, that is where it will be void. Okay? But the other part that is not inconsistent with the Constitution, it does not make the entire law void. So if a law is found, and we say that, oh, this law says in one breath this, and another breath it says another thing. If in the first breath what it says is inconsistent with the Constitution, the provision is that that aspect is what doesn't work. But the other part that is not in contravention with the Constitution shall still remain. All right? So we've understood what we mean by the Constitution being the source of law in Ghana, and we are saying that it is the supreme law of Ghana. Let's try and look at the B part of Article 11, Clause 1B, what it mentions there. B mentions enactments made by or under the authority of the Parliament established by this Constitution. You saw B. So now the Constitution becomes the supreme law, and the B says that an enactment that is made by Parliament, and of which the Parliament is the one that has been established under the authority of this Constitution. So that's our second source of law. All right? So if there's an act of Parliament, we call it an act of Parliament because that is the primary duty of Parliament. What Parliament does is to perform an act. So the handiwork of Parliament is to bring out the laws. That is why we call it an act of Parliament. Sometimes you may hear that we may refer to it as a statute. A statute is also like a written law that has been promulgated or that comes from Parliament. So any particular enactment from Parliament, of which the Parliament also derives the power from the Constitution, also constitutes the laws of Ghana. So in Ghana, we have several acts of Parliament. For example, we have the Act 1036. The Act 1036 is what we call the Lands Act. It is the act that has been provided or enactment by Parliament that seeks to explain how lands are administered and used in Ghana and all that. So if you want to know the laws in Ghana, you can also look at the Lands Act. That is the Act 1036. That is an enactment of Parliament. We may also have the Revenue Administration Act, the Act 915. That also explains or it refers to the laws that govern the way taxpayers' money is taken from the taxpayers and how the administrative processes that goes through with the way we use the money. If there are challenges with the taxpayers, who goes where, what do they do, and all that. That is the Revenue Administration Act, Act 915. We also have the Companies Act. We have Act 29. Act 29, as you know, it's also an act of Parliament. That is the Criminal Offences Act and all that. So the sources of law in Ghana, secondly, is the acts of Parliament or the enactments by Parliament. It also constitutes a source of law. All right? Okay, let's proceed and see the third one. C, Article 11(1)(c). Any orders, rules, and regulations made by any person or authority under a power conferred by this Constitution. Did you notice that? All right. So now this gives us the third level of the laws that we have in Ghana. It says that orders, rules, and regulations made by any person under an authority by another law or an act of Parliament. Orders, rules, and regulations. What exactly do we mean by that? All right. See, for example, there may be a statute or an act of Parliament that will create a certain body or confer power to somebody. For example, here we have the Electoral Commission being a constitutional body, all right? A constitutional creation. So the Constitution creates the Electoral Commission, and the job of the Electoral Commission is to see how they administer and go about public elections that are conducted in the country, amongst other things. How to demarcate other aspects of the geographical regions of the state, such that we can have the electoral regions and all that. That is the duty of the Electoral Commission. Their duty, as you may also know, may include trying to register voters, get to understand or compile a voter register, for which voter register will be used by deserving persons to exercise their franchise on election day, and etc. All right. So what the Constitution is saying is that if following that particular creation of the Constitution of the Electoral Commission, now the Electoral Commission wants to perform any other act and wants to give any further rules, any further sub-rules or legislation or anything of such sort, those other things, they are also part of the rules or the laws of Ghana. Okay, so if you look at it carefully, you realize that the orders is written with capital O, the rules is capital R, and the regulations also got capital R. It means that, as you know from your basic English, that is a proper noun. It is a specific designation to a special kind of rule. All right, we'll come back to this. But now let's quickly turn to Article 11, Clause 7. And we'll try and strike the correlation between that and what is being mentioned here. Then I'll give you an explanation as to why or what exactly falls within the ambit of a rule, an order, or regulation. Article 11, Clause 7. This is what it says in the 1992 Constitution. 7. Any order, rule, or regulation made by a person or authority under a power conferred by this Constitution or any other law shall A. be laid before Parliament, B. be published in the Gazette on the day it is laid before Parliament, and C. come into force at the expiration of 21 sitting days after being so laid, unless Parliament, before the expiration of the 21 days, announce the order, rule, or regulation by the votes of not less than 2/3 of all members of Parliament. Did you notice what Article 11, Clause 7 mentions? So this particular rule, orders, or regulations that is being mentioned, if it has to constitute a law, it first has to come to Parliament, be laid before Parliament. If it is laid in the Parliament, it is published in a Gazette. Then after 21 days, it now becomes operational or effective. It becomes legal. It becomes a law. All right, unless Parliament by 2/3 majority decides to strike that out. So, guys, the point is this. If you take the effect of 11 Clause 1C, what it has mentioned about orders, rules, and regulations, and also you take Clause 7, which says that it has to be brought before Parliament. What it simply means is that what we talk about, or what we mean, or what the Constitution means by the law relative to an order, rule, or regulation is any particular order that is intended to be legislative in character. I repeat, any order, any rule, any piece of regulation that is intended to be legislative in character. And when we say legislative in character, it seeks to set down guidelines for the entirety of the Ghanaian populace, not just a particular section. It becomes part of a binding law that will bind generations upon generations unless Parliament has decided to repeal or change that particular order. It becomes a regulation. It becomes legislative in character. That is what we mean by an order, rule, or regulation. So it does not just mean that if the Electoral Commissioner just says A, that becomes a law. That's not what it is. If what he wants to do or what the Electoral Commission wants to do is an action that will seek to bind the entire Ghanaians in the way elections are conducted, then it becomes legislative in character. Clause 7 is saying that parliamentary approval has to be sought for that thing to become a law. This is what we sometimes call a subsidiary legislation. Okay, so you might have heard the words like subsidiary legislation, or you might have heard LI, right? You might have heard those particular CI, all those things. They are rules or regulations. Anytime there's an LI, the LI means legislative instrument, which means that it is an order that has been brought to court and Parliament has added to that. That is what we call subsidiary legislation. It is subsidiary in the sense that it adds on to the existing statutes. So, for example, when you have the rules that it operates in, with the rules that the courts operate with, like let's take, for example, the Circuit Court and the High Court. You know, we call that the CI 47. You might have heard it before. The CI 47 is another subsidiary legislation. It's a legislation that has been created pursuant to Parliament. So all this is also part of the rules or the laws in Ghana. All right. So at this juncture, we've mentioned the Constitution as being a source of law. We've mentioned enactments of Parliament as being source of law, and we mentioned others, rules and regulations, and we are saying that they are legislative in character, or ought to be legislative in character, said that they can receive statutory authorization by Parliament, and they are considered as part of our rules. So there's an LI that governs the Legal Professions Act. There's an LI that always ministers may have to go to Parliament to take those LI, said that they can now bring out rules and regulations that will be legislative, bind Ghanaians in their entirety of operations around the state. Hope you're fine. Okay. All right. Now let's look at the D part of the Constitution. When we now look at the fourth source of law, Article 11, Clause 1, D. The existing law. So you see, the Constitution mentions the existing law. So apart from the subsidiary legislation that you may have, you also have the existing law. What is the existing law? Now, let's just quickly go back to the Constitution as it provides answers to what we mean by the existing law in Ghana. So still under Article 11 of the Constitution, let's see existing law. Now, Article 11, Clause 4 mentions, the existing law shall, except as otherwise provided in Clause 1 of this article, comprise the written and unwritten laws of Ghana as they existed immediately before the coming into force of this Constitution, and any act, decree, law, or statutory instrument issued or made before that date, which is to come into force, or after that date. You saw what the Constitution explains to be the existing law. It's saying that prior to the coming into force of the Constitution, that's the 1992 Constitution, any other act or decree or law that was there, it becomes part of the laws of Ghana. All right? So, for example, you know that in Ghana's history, we've had situations where there were coup d'etats, and after the coup d'etats, there were military interventions where military decrees were given, and it was being operated at the time. Okay? One of them, for example, is the PNDC Law 111. You might have heard it, the Interstate Succession Law. Going to school, you hear PNDC Law 1111. If someone dies where he has not done a will, okay, how do we deal with the properties that he has left behind? Now that law came into force before the 1992 Constitution. So the Constitution is saying that when we talk about the laws of Ghana, the existing law means that all those laws that were there, okay, whether it was made by a military regime or not, okay, all those laws that were there prior to the coming into force of the Constitution also constitutes the existing law. All right? So you have, for example, the NRCD 54, okay, the NRCD 323, that is the Evidence Decree Act. How the rules that govern the way evidence is proffered in court. This was given before the 1992 Constitution. But by virtue of the Constitution statement here, all those are part of the existing laws of what? Of Ghana. All right? That is what we mean by the existing laws of Ghana. Now, let's look at E, as the Constitution also mentions, Article 11, Clause 1, E. E, the common law. So you see, the Constitution also mentions, finally there, that the common law. What do we mean by the common law? Again, let's continue with our readings in the Constitution, as it explains what we mean by the common law. Article 11, Clause 2. The common law of Ghana shall comprise the rules of law generally known as the common law, the rules generally known as the doctrine of equity, and the rules of customary law, including those determined by the superior courts of judicature. Did you notice in Clause 2 of Article 11 about 3 components or parts of what we refer to as the common law of Ghana? It mentions that the laws that is always known as the common law. All right? It mentions the rules of equity or the doctrines of equity. Then it mentions customary law, for which customary law includes the ones that have been determined by the superior courts of judicature. So what exactly do we mean by this? Let's try and explain them. All right, so we talk about the common law, the first part of the common law that is mentioned in Clause 2. Now, you know that Ghana was colonized some time back by the British. When the foreigners or the British colonized Ghana, there were laws those laws were pertaining in England, and those laws were being used here. So much of the principles or legal principles that were birthed to our new country, Ghana, after 1957 or prior to 1957, were laws that were deeply rooted in English culture and tradition and all that. So some of these principles were there, okay, several of them. That is what we refer to as the common law. So the English law has always still retained that kind of influence on the Ghanaian law because the principles have always been restated and it keeps on improving and all that. So all bit of that refers to what we mean by the common law. When the Constitution mentions the common law, we are saying that those particular laws that were embraced by Ghanaians when we came into independence by Ghana, those particular common law is still part of Ghana's law. So our sources of law will also include those English laws that were embraced into Ghana's order after the independence and all that. That is what we mean by the common law. Then it mentions doctrines of equity. You might ask, what do you mean by equity? Well, in our later discussions, we will try and devote an exclusive attention to what we mean by the doctrines of equity. But equity simply means that there are certain things that if you put the law aside, morality and common sense should be able to tell people that this thing is right, this thing is wrong. That is much of what we mean by equity. So the law is saying that when we are talking about law in Ghana, we are not just looking at what we have written in our statute books. We are also considering the moral construct of the society. That is, in part, what we refer to as the doctrines of equity. So, for example, imagine that someone goes into a transaction. He is an illiterate. He has never gone to school before. And he wants to sell his property, his land. I'm an educated person, as an example, or you are an educated person. So you meet him up and you have a discussion with him. And you tell him that, oh, how much are you selling this land? Then he asks you, say, how much will you give me? He is not literate. He has not gone to school. He doesn't actually possess the depth of knowledge that you have. Then you tell him that, oh, this land, I'll give you 2,000 Ghana cedis. Then he says, oh, 2,000 Ghana cedis, thank you. Because I've not even eaten for the past 2 weeks. So 2,000 Ghana cedis I take. Then you take the 2,000 Ghana cedis and pay him. Now, ask, do you think that that is fair? Do you think that it is good? Is it just? Aha. Obviously, you may be thinking that, oh, but that's wicked. That's cheating. That's bad. That's evil. That's sinful. You know, you might not have studied any law, but you begin having expressions of these particular feelings being immoral. We call that in law, it is unconscionable. I mean, it is so unfair, grossly unfair. So the doctrines of equity means that there are certain principles that over time, the courts have come to appreciate that these things are a template of, or a framework of morality, or a framework of good conduct. That is what we refer to as the doctrines of equity. Later in our videos, we'll try and spend time and explain to details what we mean by those doctrines of equity. But it suffices to say that the doctrines of equity are part of the laws of Ghana, of what we call common law. Then it mentions, finally, also that the customary law, and which customary law includes the one that pronouncements have been made on by the superior courts of judicature. What do we mean by that? You know, every neighborhood or community in Ghana has got their own way of life, their own practices, how they do their inheritance, their succession, the way they marry, the way they transfer property, and there are things that vary. The Akans have got it, the Gas have got it, the various tribes, the Dagabes, the Frafres, the Kusasis, several of them. The law is saying that when you talk about Ghana's, the sources of law in Ghana, all those customary laws are equally recognized, including the ones that the Supreme Courts or Superior Courts of Judicature has made pronouncements on them. When we say Superior Courts of Judicature, we are referring to the High Court, the Court of Appeal, Supreme Court. So if there is a particular custom and that particular custom has received Supreme Court decisions or a decision of a High Court or a decision of a Court of Appeal, when we are talking about the customary laws of Ghana, we don't just go and ask about that. We also include those ones for which the Supreme Courts have made pronouncements about them. I'll give you one example, then we'll conclude our discussion on all these things. Now, it is very common that in Ghana, in many communities, there is what we call family property or family land. For example, if someone builds a house, sometimes there are litigations here and there because members of his extended family feel that they are entitled to some kind of rights in the family property. All these things are part of our culture, that if someone belongs to a family, an extended family, when he dies, there should be some kind of portions of his estate that should go to his family. Now, in a Supreme Court case, the trial was recently decided and it was delivered by the current Chief Justice. At the time, she was not the Chief Justice, Justice Gertrude Arabayi Saba Tokono. And the case is entitled Teresa Boachi versus Opanyi Kwame Sedu. This was what the Supreme Court said in what constitutes a family property by court. Where no members of a family have been shown to have contributed to the acquisition of land or construction of a house, it must only be in the face of uncontested evidence of a deceased person handing over self-constructed property to the family as a gift, or allowing the use of that house by various members of that family during the lifetime of the one who built it, as if the house were jointly owned by that family, that a court shall find itself able to declare such a property as family property. Even within that context, there must be clarity on how family is defined. You didn't notice that? So this was the recent case of Teresa Boachi and another versus Opanyi Kwame Sedu, decided by the Supreme Court. Did you notice the pronouncement that was made by the Apex Court on what we mean by family property? So customs and places may differ as to what will constitute a family property, but this statement of the Supreme Court is saying that if someone has a self-acquired property, unless during his lifetime, the manner that he dealt with the property in relation to the extended family was said that he gave an unequivocal notice that the family had a share in it, it will not constitute a family property. So that becomes our customary law. Okay, it becomes part of our customary law in Ghana that when we say family property, this decision by the Supreme Court is the latest inclusion to that set of family property. Guys, hope you understand that. So basically, all these things are the sources of law in Ghana. Again, the Constitution, enactments, acts of parliament, orders, rules and regulations, existing law, common law, and we've explained all the components in there. This is what forms the bedrock and foundation of Ghana's legal order. If any laws are going to emanate, will be worked with, will be educated upon if matters come to court or any particular tribunal, any adjudicatory body, these principles or these groups should be the one that should constitute proper law in Ghana. Hope you understand that. All right, stay tuned, stick and stay. As in our subsequent videos, we'll now try and discuss the structure of our court systems here in Ghana.